Okay, hi. So this is our second installment of our mock trial video series, and today we'll be talking about objections. So objections are basically formal evidentiary challenges in which people or attorneys can get up during witness testimonies, during cross examinations or direct examinations, and basically object to certain claims made by the opposing team. Objections are also objections to exhibits of evidence. So at the start of trial, the judge may ask if there are any objections to this exhibit from being used during this trial, and a team may or may not decide to object to using that exhibit. So objections in mock trial for like the objections that we'll be talking about in this presentation can only be made during the direct and cross examination. So objections can't be made during pre-trial or opening or closing. And yeah,
All right, we'll go on to the first objection, which is unfair extrapolation. Unfair extrapolation occurs when a witness creates a material fact, and a material fact is an important fact that will impact the case. So, for example, if I have a witness named John Doe in a murder case, and the witness statement for John Doe only mentions that uh, John Doe saw the defendant walk around where the victim was last seen. Then unfair extrapolation would occur if Doe claimed during the trial that the defendant was the murderer just because they saw him walk around where the victim was last seen. Unfair extrapolation prevents facts being created that could give one side an advantage in the competition.
yep. So the next objection is relevance. And this objection basically attacks evidence that is considered irrelevant. And so evidence is only relevant if it has a tendency to make a fact that is important to the case more or less probable than the fact would be without evidence. Also, relevance can be used if a piece of evidence is brought in during a direct or cross examination, but it has nothing to do with the line of questioning that is being followed. So, for example, if I'm asking about what happened during a murder scene, and then all of a sudden I ask about what happened like 10 months ago regarding this person's what some person did at like a cafe or like a party 10 months ago, that would be completely irrelevant to what I'm asking. And so you can object to that by saying it's irrelevant.
All right, the next objection is more prejudicial than probative. So this is a rare objection and it's not really used in competition, but the objection attacks evidence where its probative value or its value as proof of some fact is substantially outweighed by the probability that its admission creates substantial danger of undue prejudice, confuses the issues, wastes time, or misleads the trier of fact, which is the judge in this case. Again, this objection is rare, so we don't expect it to be used very often in competition.
So the next objection is laying a proper foundation. And basically, before a witness testifies about some like personal knowledge or opinion or facts, you have to show the attorney who is either cross or direct or who is examining the witness has to basically lay proper foundation. So for example, if I am direct examining Andrew and the first question that I ask him is, did you see the defendant leave this scene? This question is objectable with laying proper foundation because it needs some sort of foundation. Everyone else in the courtroom needs to know what scene I'm talking about. If this is the first question I ask, it's going to like be really confusing for other members of the court because they won't know what I'm talking about or what scene I'm referring to.
Okay, so the next objection is personal knowledge slash speculation, and this is a very crucial one. The speculation attacks questions that could require the witness to speculate or conclude about something that they do not have personal knowledge about. Or you could attack testimony if what the witness is saying is kind of a stretch. And some reasonable inference is fine, but this objection is for what we would consider unreasonable inferences. Now, you can respond to speculation objections by saying that what the witness said is in the record by citing a page or a line reference, or you could argue that it was a reasonable inference. And one way to say that it is a reasonable inference is to argued that the witness was testifying to their five senses, which can be acceptable in some responses.
So the next objection is an opinion testimony. And this only can happen if the testimony is not from an expert witness. An expert witness is usually like a doctor or a psychologist or someone who is an expert in their field of study. This is when the witness isn't testifying to facts, but they have to but they're basically testifying to something that is their opinion, like as per the name. The only way that this can be admissible is if the testimony is based on the witness's five senses. So, like what Andrew mentioned earlier about how the witness can testify to something if they testify based on their sight or their sound or like anything of that sort. And if it's helpful to clear understanding of their own testimony. So if they need to testify to something prior to testifying to something else in order to clarify what the following testimony is about, that opinion testimony can be admissible if it helps to clarify their next line of reasoning.
All right, so the expert witness is basically the same as the previous one. So a witness cannot testify based off of their opinion unless they are an expert witness. And this objection is kind of to attack any sort of testimony that doesn't seem to have like a foundation laid by an expert witness. But again, an expert witness is immune to most of the objections that a normal witness may face because they are an expert and they are allowed to testify to their own knowledge and their own opinion.
Okay, so the next objection is character evidence. And so the objection is basically if a witness testifies to improper character evidence and improperly characterizes another witness. So for example, if I am cross-exing Andrew and then there's another witness and Andrew says, "Oh my God, this witness was so mean to me. They always glanced at me in really weird ways and they were a terrible person." That is improper character evidence because there is no way to tell that that witness was a terrible person just based on the evidence that Andrew brings in, right? So they're improperly characterizing the witness. If you are on the defense, you can respond to this by saying that, or the defense has the ability to introduce evidence of their own defendant's good character, or the defense can introduce character evidence of an important prosecution witnesses. So these are two responses that you can bring up to character evidence if you're on the defense.
All right, so the next objection is outside the scope of cross-examination, and this is a redirect objection. So we after direct and cross-examination of a witness, the party who originally called up the witness can opt to ask redirect to the witness. Now, the goal of redirect examination is to attack anything said during cross-examination. So this is kind of common sense where it's you cannot ask a question that was not asked, that's not a response to a question in cross-examination.
Okay, so next we'll be going over leading objections and leading questions. And leading questions are basically questions that subtly prompts the witness to answer in a certain way. So for example, if you ask, do you have any problems with your boss? The question is basically prompting the witness to question the employment relationship with their boss. But a better question would be something like, tell me about your relationship with your boss, because instead of asking for a direct answer that is basically implying that there is a certain answer, it gives the witness more free room to respond how they want to. And so the general question is much better than a question that basically encourages the witness to ask in a specific way. And so if you were to respond to a leading objection or leading question objection, you would just have to rephrase your question on the spot.
And one thing to note before we go on is that most of the questions that are leading will imply a yes or no answer, because those will be the most direct way to get an answer to your questions. So for example, in the example here, it's, do you have any problems with your boss? It implies a yes or no answer. So if you can reasonably believe that a question is only asking for a yes or no answer in direct examination, chances are it's the leading question. Right. The next objection is the compound question. So this is where an attorney asks a witness two questions in one line of in one sentence. So it joins two alternatives with and or, which prevents the interrogation of a witness from being as rapid, distinct, or effective for finding the truth as is reasonably possible. So you can break it, and the easy way to respond to a compound question objection is that you can break the question up into two parts, and then have the witness answer the first part before you move on to the second part of the question.
Yep. So the next objection is a narrative. And a narrative is basically when a witness goes on and basically describes what happens for a really long period of time. Or the same thing can happen with the attorney. If the attorney is asking a very long and like multi-winded question, that can also be objected to by with a narrative objection. And so responses and questions should always be really like prompt and really quick. If they end up going on for like I would say more than 3 to 4 sentences, that's when it starts becoming a narrative. And so the way you would respond to a narrative if you're being objected to is to either rephrase your question to ask for a more concise answer, or if you're the witness, you would just respond in a concise way or just cut it off and like end there.
All right, so next is argumentative questions. So during cross-examination, you might be tempted to pressure the witness into saying something that favors your side of the case. So what happens is that, and sometimes you might think that you should ask the witness, like, how can you expect the judge to believe that? But that type of question is actually objectionable because it's argumentative. An argumentative question basically challenges the witness about an inference from the facts of the case. And the cross-examiner cannot harass the witness or unnecessarily interrupt the witness's response. And if you do that, you might get points taken off and you will not look good in front of the judge or the scorers. So if you have, so if you're being objected to, your best bet is to either rephrase the question so that it doesn't sound argumentative or you're not necessarily harassing the witness, or you should move on to a new line of questioning.
So the next objection is asked and answered. It's pretty straightforward. It's when you ask another question that the witness has already answered. So for example, if I ask Andrew, what were you doing on July 26th? And then he answers, and then I ask again, what were you doing on July 26th? Or if I rephrase it in a way that's like, what were you doing on the day after July 25th? I'm asking the same question essentially. And so you can object to that by saying, oh, this question has been asked and answered. And so to respond to this, you basically either move on because it's already been answered, or you explain why you asked the question again. Say you bring in like a unique that answer elicits like a unique element that the previous question didn't.
All right, the next objection is vague and ambiguous. So this is an objection that is raised after a confusing or convoluted question. And the goal of the objection is to prevent like answers that are seemingly insufficient to a question because the witness did not understand the question properly. So if you have a proper question, then a witness can answer it to the best of their knowledge. So let's say we have a question that's like, does it happen at once? That's very vague because we don't know what we're talking about with it and whether it and what like it refers to. So one thing to note is that there is substantial overlap between the vague and ambiguous objection and the narrative objection. But the narrative objection attacks testimony that has gone for a very long time and where the answer might be diluted into the long testimony. But the vague and ambiguous question attacks the question asked by the attorney and not the witness's answer. So it is much more effective in conveying a message that it is the attorney's problem that the question is being phrased weirdly and the witness cannot answer properly.
Yeah, so the next objection is for a non-responsive witness. So if you are asking the witness a question in cross-examination and they aren't responding, you can object to that by saying that the witness is being non-responsive. For example, if I asked a witness what they did on this day or like X date, and then they respond by saying, oh, they give something like really random by saying, oh, like I work at this shop, or like they don't respond to like my question, then I can object to it by saying that the witness is being non-responsive.
All right. The next objection is hearsay. This is one of the most important objections in mock trial and in trials generally. Hearsay is when a witness testifies about a statement made by another person or uses the contents of the other person's statement to prove a fact true or false, or which is essentially offered to prove the truth of the matter stated. This is important because if the statement is not being offered to prove the truth of the matter stated, then it is considered to be not hearsay and is admissible. But in general, hearsay is inadmissible because the actual declarant of the statement in question is neither under oath on the stand, nor will they be cross-examined. Now, there are several hearsay exceptions that we will go over right now.
Okay, so here's a list of all hearsay exceptions. We're not going to be going over all of them because many of them are very straightforward, but we're going to be going over the ones that people usually have the most trouble with.
All right,
Okay,
so
yeah,
so
okay,
declaration
so
against interest. Oh,
you can go.
So basically, declaration against interest is where a statement in question is against the declarant's economic, legal, criminal, civil, or general interests. So if, let's say, John testifies that Jane told him that Joe stole money from his Joe stole money from John's bank, right? It's not considered hearsay because the statement in question. Actually, no, that's a bad example. Shoot. Okay, we'll just move on. We'll just move on.
Okay, so the next exception is excited utterance. And so hearsay is allowed if the statement in question is made by the declarant during or shortly after a startling event from which in which the declarant is still influenced. So basically, if some person just got robbed and then they like say something, if that like testimony gets brought up in court, that would be excited utterance because they're still under the influence of like just being robbed, and so that would be admissible by excited utterance.
Okay, so the state of mind objection, the exception is kind of like the excited utterance one, where it's like the statement shows that the witness or the person was in some sort of state of mind that was crucial to why they did like an action. So like let's say from this latest case, which was People versus Crotty, right? You had Remy Montoya, who was taking a briefcase from a California state official, right? And while he goes out, he suddenly sees the official coming back from the house. Now, what happened is that afterwards, Montoya hit the official in the head, and then he repeatedly apologized before he ran out of the house with the briefcase. And when he got to Crotty's meet and greet, which is where he went after he hit the official, he was repeatedly like babbling as to like what happened, and he couldn't really be coherent. So you could argue that as if you were like if Crotty was testifying, right, you could use this as to show that Remy Montoya was in a delirious state of mind.
Yeah, just to add on, excited utterance and state of mind are pretty similar, but it's important to know the difference between them. So yeah, just make sure you have that down. So the next exception is records made in the regular court of business. And so hearsay is allowed if the statement in question is made in the form of a recorded like business or government procedure. So if it is literally like recorded down in a government procedure or a legal procedure, then that is when hearsay is allowed, compared to like hearsay being made when someone like passes by another person and hears something they say. This is like a legal like documentation of something that actually happened.
All right, the next exception is admission by party opponents. So hearsay, this is a prosecution exception. So hearsay is allowed if the statement in question was made by a person and is being offered against that person by an opposing party during trial. So because you obviously can't have a statement made by the prosecution, this exception is reserved for the prosecution if the defendant says something that might potentially be incriminating. So if the prosecution brings up the statement that the defendant said, right, then it would be considered admissible and you can't object to it on the grounds of being hearsay because it's admission by party opponent.
So the next exception is adoptive admission. And adoptive admission is basically where a statement is offered against a party and that the party with knowledge of the content of the statement has bywords or other conduct adopted as true. So the example for this would basically be if a suspect is in a murder case and they are booked into jail and placed in a cell with another individual, and then that person's cellmate asks the suspect questions about why he was booked, and then the suspect admits to the cellmate that like they did commit a murder. And so it would be adoptive admission if basically like the other like there's another party and that party has basically verified the words of like the person in question. Yeah. So those are all the objections and all the hearsay exceptions we'll be going over today. So yeah, thanks for watching. Let us know if you have any questions and we'll see you in the next video.